Subcommittee meeting. Today is Tuesday, April 28, 2026. And I said the record reflect the subcommittee members that are present, as well as our attorney and acting director for this hearing. First matter on our agenda will be approval of the minutes from February 10, 2026 and April 13, 2026. I would ask for a motion to approve.
Move approval.
The motion's been made. I will second it. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? That motion carries. Next matter will be the update on scheduling a public hearing on the Buttonwoods matter. Turn it over to you. Turn it over to Attorney DeSisto to give an update. Or
Okay. When this matter was last before the subcommittee, the vote was to forward the matter for a public hearing in the city of Warwick. That needs to be scheduled. That's the next step in this process. And I think it's just a simple matter of contacting the city of Warwick and making arrangements for a public hearing in a public building down there. I understand it's difficult. You're still doing your Spring Avenue extension in Westerly. But that's the next step that you need to do here. And I know that the parties in interest wanted to speak.
Yeah, just a correction to the record. The last time.
why don't you come up,
Yeah,
Chris? Yeah.
Christopher, the video attorney for the respondent PBA Buttonwood Beach Association for this matter. When we were here last, when I had to remind the forum that legal counsel was going to prepare a recommendation, a report, which from a prior meeting, you were going to allow the parties to respond to that report. We did that. There was no recommendation that it go to or there was a vote by the subcommittee to go to public hearing because Mark Hartman or you, Attorney Hartman or you, needed to digest our replies to your recommendation to determine whether or not there was, at the conclusion, an apparent incipient dedication. And I spent a lot of time providing both legal and factual basis to why that incipient dedication did not occur, which was somewhat, I would say, overlooked by legal counsel. Mark Hartman wrote it. I think he set forth a very sort of talismanic, simple test. The recordation of a plat automatically equals incipient dedication. Even the case law, which he cited to, shows that no, you need to look at the extrinsic evidence, particularly when there is ambiguity or less than certainty as to dedication. And that was well laid out in my reply, which, as you recall, you set forth. I read it, reviewed that no, there will be a reply by both parties submitted on the same date. Of course, other papers were submitted thereafter. We can get to that objection at a later date, but there was no recommendation or vote by the subcommittee to go to a public hearing. That's the whole purpose of the exercise of us submitting our replies.
Okay, that's not my recollection at all. And Lisa, if you can just tab back to the minutes of the meeting. This is going forward not on the question of dedication. It's on the question of public use.
Understood. My argument has always been you don't get to acceptance unless you satisfy the first prongs. 2 prongs, right? Dedication and acceptance. And so Mr. Hartman's report, as I said earlier, came to that talismanic test. If you record a plat, therefore, it's an automatic incipient dedication. When in fact, the case law that not only did he cite, but I cited in my reply, it goes far beyond that simple talismanic test. I was hoping that you would have read the reply, then you would say, hey, wait a minute, maybe Mr. Video is correct, that it does require us to look outside the 4 corners of a recorded plat if there's ambiguity, silence, particularly the actions of both the purported dedicator, government actors, municipalities. Moreover, which is pointed out in my brief, is that the first case that speaks to incipient dedication was articulated in 1887 by the Rhode Island Supreme Court. This purported recipient dedication, recordation happened in 79 and then 82. So they could, that is the dedicators supposedly could not have understood what their intent was when they recorded it, because that ruling, the first ruling in Rhode Island, came 5 years later, which further goes to looking beyond the four corners, looking at the intrinsic evidence, like they did down in Newport in the Lynch case, like they did in Baruto down in Westerly. They all looked at what other factors, rather than just, again, simple recordation of a map. That was well articulated and argued in my reply, which you asked us to do, instructed us to do, based on an earlier promise in an earlier hearing. But you can look to see his attorney. Okay, on that, because I reviewed the video. I reviewed the video at the very end of our matter. I do that all the time, and that's how I got to us doing a reply, if you recall.
Mr. Langsett?
Richard Langseth, the petitioner. I would like to read the act of the General Assembly on May 1715. Anno Regi Regis Georgi Primo, George I in his reign, made and passed by the General Assembly of His Majesty's Colony of Rhode Island and Providence Plantations, held at Newport the 4th day of May, 1715, an act for the convenient laying out of highways and roads in the several towns within this colony where wanted, be it enacted by the General Assembly and by the authority of the same, that the proprietors of all and every town in this colony shall with all convenient speed take care to lay out convenient highways and roads from town to town. In this case, from the East Greenwich Townhouse to the Buttonwoods Point, and to market and mill, etc., within 3 months after the publication hereof. And in the case of said proprietors shall refuse or neglect to do, it shall and may be lawful for the town council of each respective town, where such defect shall be, in order to appoint a jury of 12 or more lawful and judicious men who have no particular interest in laying out the same in such towns where such defect is and shall be found most beneficial for the interest of His Majesty and the benefit of the subject, to which the jury shall first duly engage to the true and faithful performance thereof. This is a statute that, as of 1715, the colony of Rhode Island and Providence Plantation had substantial problems with people trying to go from town to town or town to market. They created a statute which said each proprietor, including this gentleman here, will file plat maps, and these plat maps will have public highways in them. This is not some case law. This is not some kind of common law. This is statutory law. In 1779, the Crown, disparus, found that Buttonwoods Avenue runs from East Greenwich Townhouse to the point at Buttonwoods. This is a map that has gone before the U.S. Supreme Court. This map is now residing in the Library of Congress and the Boston Public Library. We've been over this several times in the past. These roads were in existence before the Buttonwoods Beach Association showed up. There is no Buttonwoods dedication of roads that are already public to some other interest. These were public roads before they ever showed up, and under the statute, they were free and available to the king and after the revolution to the General Assembly and to the people of Rhode Island to freely transport business and pleasure to the shore, as was guaranteed in the Constitution in 1842. In 1840, William Harrison, candidate for president, had a clam bake at Buttonwoods on the 4th of July. 10,000 people showed up. there were two steamships that came from Newport and from Warren and used the Buttonwoods dock at the point at Buttonwoods for the people to walk up Buttonwoods Avenue and over to the clam bake at Old Buttonwoods. There is no doubt of public use long before the Buttonwood Beach showed up. In 1870, the Beers Atlas, this is the atlas that is used throughout New England to find if road surveyors are dedicating roads to the public and gathering up people in the neighborhood to fix and repair these roads. The Beers Atlas of 1870 shows both roads as public highways long before these people showed up. In 1851, there was a controversy about the Tiverton Ferry at what is called the Stone Bridge. And this case is called Simmons versus Cornell. And what happened is Mr. Simmons attempted to adverse possess the road going to the ferry. And Mr. Cornell was the highway surveyor. He went into the road and attempted to repair the road. And Mr. Simmons said, you can't come here. This is not a road. This is private property. It went all the way to the Supreme Court. And the Supreme Court found that the 1750 statute was true, that the road was a public highway by statute. The highway, by the way, was established in the year 1700. Since that time, there have been several cases, including the recent Misquamicut case, not in a Supreme Court decision, but in the Superior Court. The state brought this case forward as evidence of the fact that these roads are public. So this is not an ancient law that disappeared. You can trace this law down through the Commission on Public Roads in 1902, which found Buttonwoods Avenue to be a candidate for a state highway. That was the year that the law of 1715 was rescinded and a new law was put in place, the highway law. And one of the very first things they did was identify Buttonwoods Avenue as a potential state highway. Clearly, this is not a private road. And this has all been given to the body before. Maybe I was not as elucid as I am now. Maybe I didn't understand the law as I understand it now. I have just discovered some of this stuff fairly recently. This 1715 Act is extremely important to the Coastal Resources Management Council. It talks about the sand path in Weekapaug that runs from the town of Westerly to the town of Charleston. That sand path falls under this law. It could potentially be a Fort Road case. This is a very important decision that the council is going to make. And it's just no reason to believe that these roads were privately dedicated somehow through some kind of petition that doesn't exist. Then what happened after that? The Beach Association went to the General Assembly. We've talked about this already. The Beach Association took its map to the General Assembly and said, Mr. General Assembly, will you create a fire district with this map and tax the people of all these public roads? There's no way that the Beach Association could possibly have gone to the General Assembly with a road of private maps and said, hey, let's have a fire district that funds private maps. That does not happen. Fire districts are municipalities. And at that very point in 1925, there's no doubt there is an estoppel. They created their own estoppel because they dedicated these roads to the public when they went to the General Assembly and asked the General Assembly to finance the roads with public dollars. That's period, end of report. And what we need to do is we need to enforce this estoppel. These people will just go on and on and on, just as they're doing in Weekapaug, until the judicial body says, no, we just can't do this. Okay, this is so obviously public. Let's move forward to the hearing. So I suggest, no matter what, let's schedule the hearing. Thank you.
My only response is that King George, there was 1715, was pre-colonial. And before Rhode Island became a state. Whatever the king was saying before that could have been adopted pursuant to common law. But that statute by the king, when he was the sovereign, didn't automatically flow to Rhode Island law. That's number one. Number two, there may be a question as to why the General Assembly would create a fire district so that it could tax those people on these private roads to maintain those roads. Mr. Langston is suggesting there's no way that the General Assembly would authorize public tax dollars. It's not public tax dollars. It's the people who live in Buttonwood Association who are paying tax, who are being taxed and paying taxes to the fire district. And thereafter, they maintain the roads. Why would the General Assembly create a fire district if they were public road? Why would the people who live in Buttonwood Beach Association pay special taxes to maintain public road? That naturally would be the responsibility of the city of Ward. Which, by the way, statute does says, which is in my briefing, the only body that can accept the road, besides public use, is a town council, not the General Assembly. Now, the General Assembly can take a road by eminent domain, which they did in one of the cases that I believe it's the Brown case, possibly that you cite too, but that was by eminent domain during the when we were fighting the British. That's a completely different scenario that we're dealing with here. Look, we have very settled law here. It's dedication and it's acceptance. That's the way a road becomes public. All our modern jurisprudence speak to that process. It's not so simple that a recordation of a map constitutes dedication, because all the case law that Martin in particular merit against that. You don't get to acceptance unless you have some sort of dedication. Town council didn't accept it. They're the ones that can do it. And there's no manifest intent by BBA to do it. All their actions during the planning and subsequent actions of them and all the other authorities, even the Rhode Island Supreme Court, and its decisions say that these are private roads. So we don't go to a point. Vote any way you want. I have it on the record. We got a video going on, I presume. I have it on the record. When and if this goes the wrong way, we can appeal it, or you could, or not. Okay, that's all I have to say. And no, one last thing.
That's all you have to say?
No, one last thing. Okay, everything that I've spoken to in my presentation was in my papers. In my papers. Not new case law, statutes, and other things that are being brought up tonight, which goes to why I cabined the process last time. Each filed a reply on the same day. Mr. Langseth filed 2 additional Rhode Island Civil Procedure motion-like documents, which I have to respond to, which they were not founded in fact or law. That's manifestly unfair. I had a case, just by anecdote. Judge Gibney, before she became the ex-presiding judge. This pro se litigant, every 2 to 3 years, he'd bring the same case against this poor guy. So finally, he brings it, I forget the judge's name, not Nugent, another bit of the end. He said, "You shall not bring this case ever again." Yes, he did. I had a file, and I got him in contempt of court. And Judge Gibney said, "Here's the remedy. Mr. DeVideo, you do not have to file any responsive pleadings, motions, anything, unless the court directs you to." In other words, when Mr. Langseth files a motion to strike or a motion for a more responsive answer, which sounds in Discovery Rule 37, I have to respond to it. Your staff, Mr. Hartman or yourself, having to read all this stuff. It should not be the case. We have a process which you've laid out. If any other court, if I was in Florida, name the judge, Attorney Sisto, where they said, "You file your stuff, no more, no less, on this date," and an attorney filed 2 more additional things, basically trying to get an end around, I know what would happen. That judge would pull us into court and say, "What are you doing? This is not what I directed you to do." And he already said that motion practice is inappropriate for this forum. When he filed the motion for summary judgment, which I didn't answer. Then he filed 2 more after you said none. Has to come to a stop. It's not fair to my client to have to continue to pay for this. Not fair for staff to have to read through these papers again, not found in the law of fact. The one where a motion to strike, I'd have to have been A, a response to a pleading, and B, there had to have been an order of the court saying you need to strike it or correct it. There's none of that. There's no basis to even file that motion. We really need to just merry-go-round and all of a sudden, or musical chairs and the seat stops. Who gets the last word? That's why you set it up the way you did last time, which I appreciate it. I don't know where we're going to be going forward, but I would like to have some clarity about the process so that everybody's on the same page, a shared understanding.
I think I'm being attacked as a pro se. And I think that is prejudicial. I may be pro se, but I'm not a neophyte. I have been working this case since 2003. This current case has been going on since 2017. The first motion he talked about was filed before he was representing. The Buttonwood Beach Association did not respond to that motion. That's the reason for the motion to strike, because you failed to respond to the first motion. We didn't at the time have these judicial rules where the court had to order motions to be answered to. I've been going to these meetings for what, 25 years? And you don't hear that kind of thing. This is an administrative body. It's not the court of law. If you didn't want to respond to something, that's fine. You didn't respond, so I say, okay, you didn't respond, so there. But all this.
I get your point.
That's all I
Got it.
have. And that was-
I'm sorry, go ahead.
All this can be discussed at another time. I think what we're talking about today is scheduling a public hearing so that the people, including myself, can speak. And then I have a question. If somebody comes to speak, I assume I have the right of cross-examination. At some point, the Buttonwood Beach Association and the Buttonwoods Fire District have to come in here and explain themselves and subject themselves to cross-examination from me. Because I don't believe there's anything in the record that the Buttonwoods Fire District has said that makes any road, anything other than completely public. And I would like them to come in here and make that statement that we're a fire district and we maintain private roads. I would love to hear that.
Okay,
I have not heard
but
that.
stop, please stop. Because I gotta tell you that the matter is down under the Open Meetings Act for a status update on this. Now, you've both made your arguments, and that's fine. Out of all of the things that have been said, and this is what I just want to say to the board, there's a question as to whether or not what the final action of this subcommittee was. My understanding was it was, time to schedule the public hearing. Mr. DeVideo has raised an objection to that. And, frankly, I'm going to have to take a look at the tape myself. That's my memory of this. And I think we need some time on that. Just schedule this for the next meeting. I'll take a look at the tape and we'll go from there. If I'm wrong, I'm wrong. I'm always the first one to admit it.
Scout's honor. I reviewed.
It's okay.
the video
And I don't doubt it, but I just want to make sure that what we're doing here is procedurally correct. And this was all about procedure. I just want to make sure that that was the last act of this subcommittee before we proceed. That's my memory. I want to make sure that my memory is correct.
I agree. I think he's right on that.
You do?
Yes. I mean, I'm not gonna lie about what happened here.
Really?
Yeah.
All I'm saying is let's have the hearing.
Well, so here's the point. That is, the fact.
Do you guys agree on something?
Yes.
Yeah.
Here's
Is that on the record?
This is what's troubling me, Sisto. The fact that you forgot that's where we left off, that we were going to submit our replies, tells me that either you or Attorney Hartman haven't actually read our papers, because that was the whole point of sending in responses to the report. And that those responses would then inform you and or Mr. Hartman how you were going to advise the council.
Okay.
And if that hadn't been done, I'm not expecting another report to come out.
It's not forget.
Yes.
It's misremembering. I want to make sure that I'm misremembering. How do I know that you guys aren't misremembering? And I did read your papers.
You did.
Believe me, I did read your papers. I know the arguments that you have.
Perfect.
I understand completely. I even know about King George. But I just want to make sure that I'm properly advising my client. So I think at this time, the matter has to be continued to the next meeting for that clarification. Thank you very much.
And
Thank you for coming out.
No, what's gonna actually happen at the next meeting?
I want to make sure that we're at that posture where it's ready to go. And if not, then a vote has to be taken to set it down for a public hearing. I thought that already happened. Perhaps I misremembered.
So it can go either way, public hearing or not.
So
That's always the case.
I'm just really confused about the motion that I presented. Now he argues that it's not appropriate, maybe that's true. But we need to at least talk about my motion at some point.
Absolutely. We're going to do that at the next meeting. Out of all of the things that were discussed today, the one thing I think that was relevant to what the matter was done in the hearing was Mr. DeVideo saying, look, you never did take that vote. And now if that's correct, then the vote has to be taken. I want to confirm that.
Yeah, I'm not clear on that either, on that particular point. I'm clear on the fact that we were thinking that, there was gonna be something happening, but whether a vote or not was taken, I'm not sure. I'm
Okay.
really not.
Do we need a
sure.
motion?
Thanks.
Thank you very much. You do need a motion, yeah.
I'd entertain a motion to continue the matter to our next date for right-of-way subcommittee to allow our attorney to review the prior record and afford us him an opportunity to then present to us at the next hearing.
I move that we continue the hearing.
I would second that. Motion made and seconded. Any discussion? Hearing none, all in favor, say aye.
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 Thank you both.
Thank you.
Thank you.
Thank you.
Nothing further to come before the subcommittee. I entertain a motion to adjourn the subcommittee. I would second that. All in favor? Aye. Meeting adjourned.